Yeah, I guess Sam gave you a good baseline of where what we were looking at, or like the whole theme of the Courts of the Future project. And yes, in the past, yeah, this is our 12th Courts of the Future web session, work session. We've had, yeah, we've gone back and we've looked largely at national courts and how to reform best national courts and court system. This is one of our first ones to deal strictly with international law and internationalized tribunals. Excuse me. We've yeah, in the past, our first web session, we looked at the great value of the courts and or the value that courts have to offer to people and society. And in that session, yeah, we found that yeah, we looked more at a statistical analysis at how courts serve society, how efficient they are, and how how efficient the courts can serve society, and how effectively they can serve society. And that was kind of the basis for all of our feature sessions, where we looked more specifically into each individual area that courts tackle. From these work sessions in each specific area, we tried to get at the end. We try to get a what we call it terms of reference, how each yeah, each area that we tackled can the key issues and problems from those areas, and how they can best be tackled, or if we come out with a way to overcome those issues and challenges from that session. Really, the key aspect, or the key thing we wanted to pull from each session for each topic is we want to discover all the holes in procedures and in costs, and in covering costs with yeah, each aspect of these tribunals, or of these of courts. I think our most successful session, surprisingly enough, as far as our terms of reference goes, is the divorce courts session. We came up with 41 specific terms of reference on that, on how we can make divorce, not just the courts, but proceedings as a whole, more effective. We thought of ways to run through like the whole divorce proceeding within one courtroom, or one courtroom, bringing in all aspects of a divorce proceeding, like property, family law, child custody, and the like. And that, along with the labor courts, was also very effective. What I would like to draw out of this session, I think is best in that regard, is to have very specific points of reference. Those seem to have been most successful. As to how criminal tribunals and procedures and funding mechanisms especially can have all the holes and problems and issues we have from those, and how we can fill those holes.
Okay, thank you, man. Just maybe a few things, because you see, what we're trying to do is look at specific courts, but we're also trying to look for the connection, to see if there's some general stuff that you could actually say about courts in general. I know there are a few things that are just surprisingly similar. One of the things that ends up happening in almost every session is the battle between generalization and specialization. You need general courts and specialized courts. And I think what we're slowly discovering is that specialized courts are always better. You then need to do a few things to make them good specialized courts, but specialization generally, or specialization within one court, so it doesn't have to be a whole court, but at least specialization is a good thing. Another one is that there are different ways in which courts and judges see their role. And there are two big, two extremes. There is, on the one hand, courts as a last resort. So you see your role as a judge or as a court. So basically, when everything else has failed, the citizens can't solve, and mediation fails, and at the very end, you do something in very last resort. And a completely different role definition, is one of problem solver. Basically, screw the rules. I've got to help these two people solve that problem, and I'm going to find a way to do this. And sometimes you can have in one court different judges with different rules. Yes. What do I need to do? I need to be in the camp. Okay. That's a scary thought. That's a scary thought. So that's another one we came up. Then the issue of complex procedures. It doesn't really matter whether it's a divorce court or a labor court or a criminal court. Grumbling about procedures that are they're inhuman, too formal. People don't really understand them. They take too long. That's clearly one. And the last one I would mention is costs. It really doesn't matter which court it is, but I mean costs are generally courts are generally seen as very expensive. And there's always this pressure to reduce costs. Costs versus access to justice, and cost versus access to fairness, etc., etc., etc. But so kind of the business model of courts, I think, is also one.
That I think is especially important today because the biggest question mark, especially at ICC right now, is how it's going to be funded into the future, and they're having a lot of funding problems, and they're really this seems to be a very big concern with shortening lengths of procedures to cut costs down.
And as we wrote down in the blog, there's lots of, the International Criminal Tribunals are such special new types of courts that just never existed before. And they have all kinds of procedural and other rules that make them additionally difficult and complex to understand. So, one way that we thought we might start is just look at international criminal tribunals and ask you the question, if you were to think of the perfect international criminal tribunal, now, just leave aside, because you're in Apple, remember? You're wearing sweaters and there's dogs running around here, so what are some of the requirements? What are some of the things that a really good international criminal court would have to do? Leaving aside whether maybe we'll just make a short list, because what we'd then like to do is look at that list, and then our suggestion is to focus our discussion a little bit on procedures, which is clearly something that's bugging the Assembly States parties and the courts and whatever, and perhaps connected with that the issue of costs. Christina, we haven't introduced ourselves, let's do that, but before I do that, Christina made a really interesting observation when we talked to her about some of the issues before courts, that she said, that's really interesting that people are always upset about costs and the procedures of these tribunals, these international criminal courts, but isn't there a fundamental discussion about their fairness? And I scratched, I don't know whether you see that. I don't think there is a fundamental discussion about their fairness or the fairness of their judgments. I mean, there's picky lawyers that say you could have decided differently, but it's not quite as fundamental as the discussion on the complexity of the procedures and the amount of money they cost and stuff like that.
I think maybe the issue of fairness, it depends who you ask, I think. And if you ask, maybe I should say I work at the Ministry of Foreign Affairs, and I'm one of the two chairs of a working group of the Assembly of States Parties that deals with expediting the criminal proceedings at the ICC. So the Assembly has been looking at those proceedings to try and speed them up. And I think the Assembly has an overriding concern to be expeditious, not at least because it has cost implications, of course, and because there's a general feeling that simply, if you look at the ICC, after 11 years, not having been able to complete a single case in first instance, well, there's not two cases in first instance, but not on appeal, it's just going too slow. The impact, so in terms of why do we need court, the impact on affected communities is just too slow. It's not effective. Whereas if you ask a defense lawyer, for example, they will always firstly tell you that the proceedings are not fair enough, and that whatever you do to expedite them will often go to the detriment of the defense.
Okay.
So I think it depends on who you ask, I would think.
Yeah. Okay, well, Thomas has now introduced himself, so maybe I should have done that. So what we were suggesting that we do, Judge Bokar, is focus mainly on procedures and costs. But we'll see where the discussion goes. And just to start things off, we were kind of brainstorming on what would the perfect international criminal court, with all the lessons that we have now, everything we've learned, do? What would it be like? And a couple of things have kind of come up in the discussion. It has to have a fairly fast or faster procedure than you have now, depends how you determine fast. Impact was mentioned as something that needed, the ideal court would have fairly quick impact. So the question is if that is how we might do that. Defense fairness, is that well worded, Thomas? So whatever you do, it has to be fair. Can we come up with anything else? Just a free-thinking list of the kind of things that determine success. When do we think they are good, that they are successful? You mentioned a few things, Michelle.
You know, I think it's important to look at performance more generally.
Right.
Because it's a whole system, and it's a system of government, state parties, etc., etc. And the necessary accountabilities that go back to national domestic governments that are part of...
Okay. That's an interesting one. So accountability.
Yeah.
I would add accountability.
And to the national levels, right?
National and, international.
All levels.
To
All levels, yeah.
national, international. Yeah. That makes them pretty unique, huh? I mean, they have to answer to such wide different groups in order to be successful. Yeah. Sure.
I think just kind of flowing from this, that it also has to be relevant to the population in the, I don't know what to call them, situation countries, to use the ICC terminology.
Yeah.
But the population, the country, which is the country of concern for the court, I think is important.
Yeah.
How to connect to that population.
Yeah. Yeah. So kind of understood. Locally.
Also accepted locally.
Yeah.
Even more important than understood.
Yeah,
Well, I mean,
yeah.
as important.
That's important.
Has to be engaged, I guess, with the local population
Yeah.
in some way, in the broader sense, yeah.
Yeah. Thomas.
Credible among fellow lawyers, so that people
yeah.
who come from the national level or from other international organs, international tribunals, come to a specific tribunal and realize that this is the kind of stuff
Yeah.
that we at our level do.
Yeah. Yeah. So credible amongst the legal community.
Which can be had also with fast sometimes as well.
For sure. Yeah. Yeah, that's interesting. You're starting to see all kinds of. Yeah. Anything else that is very specific, or not so specific, but I mean that we would want these courts. I guess affordable. I mean,
Accessible. Yeah.
Okay. Accessible. Affordable.
Accessible to whom?
Yeah.
I was going to link it to credibility among professional, local members of the legal profession, etc. But also, linked to credibility, accessibility. Because I think in some instances in the African continent, there is a perception, although it's a subjective, perception is subjective normally, but from just the circles I've been in, is that they have, the view is that there's an underutilization of the ICC for some countries, that are very overt in some of the human rights atrocities, but in terms of accessibility, unless it's a matter that makes huge global media and importance, it doesn't really have consideration for whether there is a matter that could be brought to the ICC. Because I think the local understanding and knowledge is that it needs to be genocide of mass scale. But I think we're narrowing in on definitions as it relates to all sorts of atrocities. And it's in that context I'm thinking accessibility.
Okay. Can we say a few more things about the fast procedure? I mean, there's what strikes me as being so. I mean, procedure is not one thing with these courts. There's so many. I was thinking about it, there's so many specific procedures that are connected with. You need a special process for getting a witness. You need a special process for evidence and cooperation at the national level. Can we say a few more things about that?
But so I don't want to demo.
Because what are the key worries in the ASP group?
I think it's a fair question. What actually are the worries? And if
Right.
it's also a matter of perception. If you speak to state representatives, you say it's too slow. But I think there are many states that really haven't studied this in as great detail as many of you will. The first question is be realistic about what is achievable. These proceedings are very complex, aren't they, Judge? And by necessity, they may take a long time. But then again, so that's one thing. The other thing is that procedures need to be in tune with the way that practitioners, let me say it differently, practitioners need to use the rules in a way that allows them to go fast. Someone said that the rules of procedure and evidence of the ICC, for example, were drafted in a permissive way, which would allow judges to use them in the way that they see fit in the most efficient way. And you could ask yourself whether a judge have always achieved the most efficient implementation of a particular rule.
And that's just drafted in a more permissive way than ICTY? I mean, is that a lesson from ICTY, or is that, do you know that? Are they fundamentally different in...
My feeling is that they are less permissive, the rules in the ICTY, because the ICTY can change the rules anytime you want. And the ICC cannot, actually, has to go through the ASP,
Exactly.
which makes it a complex procedure for changing the rules. I wonder whether this should be changed, actually. Because not always you can achieve through interpretation of the rule. Most you can do through interpretation of the rule, I concede. But sometimes you need a change of the rule, especially to make it clear to the users, particularly defense, which is exactly the rule. You can do it through case law, but not everybody is used to that, especially in civil law countries.
But it might, well, it depends on the court, but I'm just thinking of the ICC, it might be difficult to do that because it's a treaty-based court as opposed to ICTY. I mean, I'm not sure, I'm just throwing it out there. I mean, if states might be reluctant to give the judges more power to amend the rules.
No, that was a hot potato in the negotiation.
But in a way,
Yeah.
I mean, the Security Council is also in the hands of states,
Yeah,
and they gave this power to these judges.
yeah,
So
yeah.
simply, maybe they didn't have the time to draft the rules. They had 2 months. Hardly they drafted the statutes, a very thin statute, and the rules said, well, somebody has to do that, let them do it. It was just a way of getting out of the job, whereas the Assembly of States Party had the time to do that.
But if I can ask you a question, if you look at the rules now and you compare them with 13 years ago when you started, are they more efficient? Or is it mainly through case law and
That's-
experience?
Many of them are case law that has been codified later. So does not change much, actually. So, for instance, skipping the examination in chief when a witness has already given testimony was done by the appeal chamber. I remember I presided the appeal chamber and said we go this way, but then they wanted to codify it. So civil lawyers say you have to codify it.
Yeah.
I'm a civil lawyer, but nevertheless I thought the case law was enough. So many rules have been changed because of the case law. But it's more efficient now. Actually, when this is a study has not been done, but it should be done. If one looks the cases of the end of the 90s, were much shorter than now. All the cases were much shorter.
In the 1990s.
Absolutely. And the beginning of 2000, same. I sat in a case with 3 accused at the beginning of 2000, the first case. In 8 months was finished. I mean, it started in March, the judgment was rendered in 11 months exactly, in February. So today would be possible.
Yeah.
You have 3 accused, 3 years is the minimum for a trial. So there is something wrong. And notwithstanding all the change we've made in the rules, with a view to accelerating the procedure. So the reason for the delay must be elsewhere.
That's an
The
interesting
organization
observation.
of the office has become more complicated.
Right.
That's one thing, and should be looked into. The machinery is too complex. And if you make a big machinery under UN rules, that's a mistake that the ICC has done, to follow the same pattern, you have a bureaucracy that does not function, actually. More engagement of the judges in the cases. At the beginning, judges had one clerk, one person clerking for them, and that was it. Now, for each case, you have a team of lawyers working. That means that the team takes the lead on it. But the team is 2 P2s, 1 P3, 1 P4,
Yeah.
P5, and that means the P2 work unless they have interns that they can have to work on the case, and the others supervise.
Yeah.
Enormous waste of time, because supervising means months of work,
Yeah.
and to people not working actually, and taking responsibility for the times. And judges, well, this I speak
Yeah.
Chatham House.
No, you don't need to finish that sentence.
Just to be clear. And judges, some that do not take responsibility, and just delegate it to the team,
Yeah.
which is clearly a wrong approach. I don't want to make names, of course, but it's a general trend this way. This organization is wrong, clearly, in a court.
Yeah.
But is that responsible for everything? There may be hundreds of reasons. The defense counsel. Defense counsel at the beginning, because the accused only did trust their people in the Balkans, they had their own lawyers, clearly, because they came to The Hague facing a prosecutor, American or Canadian, whatever, a common lawyer, English, that could really cross-examine witnesses, and they had never done a cross-examination. Now, it's obvious that somebody had never cross-examined a witness is not able to do that. It's a technique you have to learn.
Yeah.
And if you never did it, so was the defense efficient? Now they have learned, even those individuals. So they are more subtle in inventing motions that may delay things that may, so maybe also on that one could, but there are many factors probably. It's not easy to, I didn't make a study, but it's a fact. Take one case with 6 accused, well, that was not my case, it was done by Cassese, the last Cassese case. In 14 months, 6 accused went from the beginning of the trial to the judgment. Today, 6 accused say we need 4 years.
Yeah. That's interesting.
Kupris case. Kupris was there
Yeah.
within 14 months. And now it would be impossible. That was from beginning of 99 to beginning of, or end of 98 to beginning of 2000, something like that. But that's not the only case. All the cases were short.
There was also on the Chatham House rules, but in the beginning of the ICC, we did a bit of a study on the organization around judges. And we visited the Canadian Supreme Court. We called some Judge Breyer from the U.S. Supreme Court. We visited the European Court, and we came to the conclusion that the International Criminal Tribunals have more clerks per judge than anywhere else, which clearly was deemed necessary, but
It's interesting that some of the things that you described really eloquently, you would think of as strengths in a system. Like we often want a defense attorney to be highly competent, to have more fairness in a system. But on the other hand, to deal with that, good defense attorneys, if they're interested in delay, can use the rules really effectively for delay. So the system has to be able to change, somewhat flexibly to deal with defense attorneys learning their way through. And these tribunals probably have a complex governance kind of system in place, so quick changing of the rules because the local court decides, the defense attorneys are abusing a portion of it. It's probably a different governance structure, and it makes it harder for the tribunals to adjust even to good things like the defense attorneys. Or usually we would think it was a good thing that judges could have enough staff. But I'm sure there's such a thing as excess in that.
But one issue to not forget is I think mistake was made at a certain moment to allow, without any restriction, without any rule, defense in person. Because it's true in the human rights instrument, one can defend in person, but the ability to defend has to be checked.
Okay.
And so that doesn't mean that one that defends in person has no time to prepare. Why? Either he can prepare or he cannot. But why should he have double time than counsel? If not able, he takes counsel.
Yeah.
So simple.
Yeah.
I mean, it's, but that was started with Milosevic,
Yeah,
actually.
that's very true.
And,
Yeah.
and that was a mistake probably that was made. But that's a common law mistake. Because in common law, certainly in many common law countries, if you have counsel, you can't take the floor at all. I personally heard colleagues when the accused wanted to add something, saying you cannot, you have to do it through counsel. It's strict. This is not the case in civil law. In civil law, if you want to add something, you may. You ask leave from the president, you may.
Yeah.
And probably Mr. Milosevic, when he was denied the right to speak, if he had counsel, decided to defend a person because he wanted to have a tribune to talk. So, but this is probably one of the factors in some cases.
Well, I think one of the things that we would deduce from all that we came across in the other sessions as well is this notion of judges being able to somehow control or take initiative, whether it's a labor court, a divorce court, or a commercial court. That comes across very often as something. It surfaces very often as something that's important. And the ability, if you look at some of the biggest innovations and moves towards this effectiveness, that's often a particular judge who takes some room and just does something. Yeah, and maybe that's something that. So, Maria, just to tell you what we've done until now, we've tried to make a bit of a list of what a good international criminal court, if we were to think of one now, what kind of requirements it should meet. And that's where this list has come from. So fast procedure, we've got a couple of things here. It should have faster impact. Well, I need not repeat. Is there anything else that we can add here?
That's one other thing that occurs to me. I'm not sure this is really in the purview of the tribunals to control, but ideally one would see their decisions implemented promptly wherever they are being implemented. You know?
Right. Right. Implementation. Of decisions. Yep. Got it. Yeah, that's a good one. Does the CICC have, I mean, from your perspective, anything?
Well, not just, yes,
What do you
from
guys
implementation of decision, but explanation thereof. I mean, you see this situation where there are being decisions being implemented, but the affected communities themselves don't necessarily understand what it
Right.
means,
That's
what
this
measurable
or not?
impact it is. Yes,
Yeah,
yeah.
yeah.
Maybe a little more transparency would
Yes,
help us.
yes, of course, transparency and outreach plays into
Right.
this whole thing.
What do you mean with transparency, Matt?
More transparency in the procedures and I guess the mechanisms, especially for the local communities where the victims come from.
So they kind of understand.
A lot of them, well, at least with ICTY, I know a lot of it's really they do a good job at broadcasting it and showing what's going on in Croatia and Serbia. I think it'd be really helpful ICC to form a similar outreach program so people know exactly what's happening,
Yeah,
as opposed to just the general notion that somebody's on trial from our area and we'll see what happens in a couple of years.
yeah, got it. Okay. So how many of these things are international criminal tribunals doing really well now? And just if we're dreaming about, you know, what these things should be doing, just one thing I was thinking, Christina, about a conversation we had this morning. So when the World Bank or let's put it, your area of work looks at these tribunals, I guess in the end, you want them to contribute to development, to economic growth, to that kind of stuff. I mean, there is a broader societal goal.
Yes, it would be wonderful if some of the expertise, present in and developed in the tribunals, if some of that got left behind as a legacy of expertise for the national or local communities that they might sit in.
Yeah. So, what is it? Local legacy or something like that?
Mm-hmm. So if local judges or local prosecutors, up to their game as a result of having had an interaction with the International Tribunal, that would be great.
May I say something?
Sure, sure, please.
I worked with the ICTR, the ICC, and currently I'm with the Special Procurador. We have just finished a 9-year project where 5 international tribunals, ICTR, ICTY, SCSL, Cambodia, and Lebanon, have got together to put together their best practices, or we didn't call it best practices, suggested practices. So we just published it online with the International Association of Prosecutors. We launched it in Bangkok at the IAP conference in November, and we put online 305 pages of consolidated practices in July and June. So it's available to all prosecutors on the IAP website. And the prosecutors are all committed to engaging on a complementarity basis. For example, to engage with the National Prosecuting Authorities. In 2007, Prosecutor Jallo called a roundtable discussion with National Prosecuting Authorities in Russia, and he promised this. In fact, tomorrow, the Special Prosecutor Hollis is on her way to Georgia to do this. I had a meeting with the Minister of Foreign Affairs, the Dutch Minister of Foreign Affairs, 2 weeks ago, and they are putting up the money to translate it into French so that it can be used. Robert Petit, former promoter prosecutor, went to Senegal, sent by his government to train the prosecutors there 2 months ago, and they will be using the document that we produced.
So in other words, there are efforts going on in the area of this local legacy. Okay, maybe we could just reflect a little bit on to what extent I find it interesting. To what extent is this being achieved by the current tribunals, and then use that as a way. Let's look at some of the more specific procedural issues. So what did you write down here? Cases slowing down. Okay, so in terms of procedure, if you were to just narrow it down, because this is tribunals in general, but in terms of procedure,
Maybe like actually some specific problems in procedural codes or procedural, procedural practice that you
what
see.
would you design? So I think we came across already this notion of flexibility. So procedures need to be flexible.
Well, I'm not sure. That's
Right.
That's the question. I think that if the rules of procedure of the ICC are flexible, they need judges that can use the flexibility in order to get the most
Okay.
expeditious. So it's not just one thing. It's hand in glove. But I think maybe I can give an example of what we, from the state perspective, look at the ICC, for example, is the relationship between pre-trial and trial, which I think where the perception is that at Rome, states were unable to overcome the differences, common law, civil law, the idea of jus d'instruction and then have a full-fledged trial. So they came up with the system of pre-trial and trial and essentially left it for decision-making by the judges at the ICC, which has so far not resulted in at least this is a perception among states, hasn't resulted in the best way to deal with these rules. If you look, for example, at the recent dissenting opinion by Judge Fernandez in the Gbagbo case, you see fundamentally different approaches as to how you use pre-trial versus trial. These are completely clashing. I think prosecution at ICC has one view, it's more prima facie test, it's a motion to dismiss kind of scenario, whereas the civil law just might be much more inclined to say, no, this is really, it's a proper mini-trial, which is a term used then, I think, by common law in a scathing way. But I think that's one of the issues where states weren't able to decide. It was left for the judges, and so far that hasn't been resolved. Of course, the appeals chamber has already had to pronounce on certain issues in Barra-Shimano, and it'll get to the issues, but it'll take more time. The question is whether states should step in and whether they are actually able to overcome the difference at this point, the difference that they weren't able to overcome in Rome. But that's a concrete issue that I think states are focused on.
And what would be the core of the differences that
Well, I mean, to talk in cliches.
mini trial or not mini trial, kind of, no?
Well, civil lawyers would say it's a complete waste of time and effort
Yeah.
if you have a confirmation proceeding and then once it's confirmed it goes to trial, you do away with the entire record and you start again.
Again?
Whereas a common law judge might say, well, look, I haven't seen all that evidence at pre-trial and a lot of that evidence actually which is used at pre-trial is not used in trial. So of course I have to start again.
Yeah.
They're fundamentally clashing perceptions.
Yeah. Well, maybe another thing just to share with you is that in especially the commercial court session we had, but also on the divorce and labor courts, this issue of case preparation also is one of the things that pops up in every single court, that if you do that well, call it pre-trial or call it something else. But a judge that has some room to sit with the parties beforehand and really map out what's going to do, what counts, that is a critical success factor for a good process. Yeah, and that's not something you can necessarily catch in a particular procedure. That has to do with the quality of the judge, the room he takes, or the judges, the culture he or she works in, etc.
You could mandate such a hearing, though.
Yeah.
And require them to do that.
Yeah.
Not leave it fully up to the judge to keep it going. Require the judge to push it
Yeah.
forward.
What would be the ideal? Can we look a little bit more at this? I mean, if we're not states parties, we're negotiating, but in this preparation phase, what would be some of the things that you would want it to do before you get to the real trial? You know, Judge Bokar, in terms of doing some of these trials, what are the critical things that need to be sorted out at the beginning? Is it possible to do a kind of some bullet points?
Well, it depends what you do at the confirmation stage first. I had the impression it's not an impression, it's a fact, that many indictments were confirmed without any reason to confirm them, because prima facie there was nothing simply. There was a description, but not any prima facie evidence. So, and this means that the prosecutor was not ready to deal with the case. And then started the case without having the evidence, especially, and was continuing investigation for the evidence during the case. This delays enormous trial. So one should have the list of the witnesses very clear, and have clear the positions. Well, safeguarding the defense rights, of course, to bring other defenses during the prosecution case, but
Yeah.
but the question should be well defined during the pre-trial.
Yeah.
And you discuss that and nothing more.
Yeah. When is
Except you need a special leave to add anything.
right?
Otherwise you won't.
Yeah. Okay, so when things are ready to go to trial. Yeah. And are there any procedural issues that are specific in terms of the specific because you're dealing with international criminal trials, that you're dealing with many jurisdictions, that you're dealing with many countries, that you're dealing with many witnesses? I mean,
I think there's a host of issues, Sam. If you look at the ICC, it has done a report last year to the ASP, last year August, in which it outlined areas. I think there were 9 classes and 24 subclasses in which the court outlined at the request of the ASP areas in which it wanted to look at its own procedures. And they go from very big issues such as pre-trial and trial to the seat of the court proceedings, Rule 100, the first rule that we were able to change, which took a lot of political effort to really get it done, just a minor rule. And everything in between, basically, from translation to case preparation to having an evidentiary record. For example, one evidentiary record at pre-trial that goes to trial, so that you have a system. I think prosecution has been thinking about that as well, and everything in between. But that's just within the court. And you're right to say that, of course, there's a whole system of states. The issue of cooperation is a major issue, which is now being debated as well in the ASP. I'm not sure it's always debated. Really, always the core issue is being debated. In essence, what it comes down to is that states must be ready and willing to cooperate with the court, because if they don't, then the court is nowhere. But that's a major issue. It dictates the success of the court.
yeah.
And it's not only the ICC, it's the cooperation issue.
Yes.
ICTR, all the
Yeah,
fugitives,
it's,
and all that. There's just, everyone knows where the fugitives are, but we just can't compare. So it's the same with ICC, same with ICTR.
Yeah. Right. These are issues in many ways outside your control. Yeah. Anything else here on things that we think these procedures should do?
Maybe one question, Sam, is how do we go about this process of changing procedures? That's something actually we're looking at in the context of the ASP. It's something that I hadn't thought about before, but really you see that we're focusing most of the time on how to define the relationship between the state's parties and the court. And if only it were so easy that the judges could change their own procedures, but the reality is that the states didn't want to give that power. And so you have this dance around each other where you need to work together, and then there are expert and NGO efforts as well that come into play as well. And how do you channel that process so that something more efficient comes out of it? And how do you measure that? I think that's a big issue as well.
And would you say that there is general agreement amongst, well, it clearly isn't amongst the states, but that there is a fair good idea of the things that need to change, but that the process for change is actually more complicated than what needs to change?
I think it depends on whom you ask. If you ask practitioners, I think that maybe at your level, at the prosecutors level, so if you put a group of prosecutors together, they'll easily understand. They'll easily come to agree on a number of issues. But here there are so many different interests at play, both political and technical, legally, so it's difficult to know where you should look for for agreement. Depends on who you ask. Yeah.
Yeah.
You're dealing with 122 states that may not necessarily want the court to work in the same way.
May I ask, how do you deal with the changes of rules in the ASB? Do you have a special committee for rules?
But it's
Or you do it in the plenary?
no, that's an interesting.
Because I wonder whether the ASB could delegate in a way and endorse simply what a committee would do. It's a relatively small committee, actually, that is elected by the ASB and at the end has the trust of the
Well,
ASB and then it's just accepted what they decide.
I think, well, the answer is there's a working group on amendments in the ASB. It sits in New York. And at the same time, there's a study group on governance, which sits in The Hague. And then there's a roadmap agreed between the ASB and the court on how to get to these procedural changes. And it's basically, as someone has called it recently, it's a ping-pong game between court, SGG, court, working group amendments, back to court. No kidding, it goes back and forth. So everybody's involved. And then the end, the working group amendments is sort of the gateway to the ASB. And you hope that in the working group amendments you can pre-cook these proposals. But by then it has gone around so much already that there are hardly any efficiency games in terms of decision making. And yes, the Assembly will endorse.
In fact, if you look at the agenda, the working program of the Hague Working Group and the New York Working Group, you will see what is important for the ASB. And if you don't get your agenda item in there, it doesn't really get the look in.
Doesn't really get anywhere. But then again, I think there are big differences between The Hague and New York. New York has a real, a UN point of view. It looks at the bigger picture, the big political landscape, whereas here in The Hague, I think we states have the tendency to micromanage the court in ways that are completely not healthy sometimes. Sometimes they are, but so that too we need to. So it's the procedure which is cumbersome.
But what would be the 3 or 2 most important procedural issues, changes that need to be made?
Like we were handed the keys to the ICC and said, "Well, let's make us good procedures." What would be your first instinct? They're really the best 3, 5.
NGOs, I mean, any particular thing you're
Yeah.
pushing for?
See, it's difficult because, you are implicated within the system that Thomas has just described, and it's hard to just generally say, actually, well, we'll do away with the states parties and let judges decide
Yeah.
what procedures they want and apply so consistently. So
No, but I mean, what's clearly coming out of this is that this is a real serious showstopper in making these tribunals work better, which will certainly develop in the trend report. It's something that a good court needs the ability to do that. Now, I must say, put it in perspective. For example, in the Netherlands at the moment, there is this big national strategy on court innovation, and it's not all that different. I mean, what's happening there? The Ministry of Justice, and then these 3 directorates between the Ministry of Justice, and then the Bar Association, and then comes the Association of Judges, and then comes the Conseil National de Magistrature, and they all have their opinions. And before you actually, so the big changes, if they happen, they usually come from a group of judges or one judge that is just able to force something through. And the changes that are made are generally not generic, but it would be like we had, it would be a particular judge in a particular type of court. So in the commercial courts, something would be kicked through by a president who just takes the space and does it. And that's where most of the innovation comes from. Michelle.
I'm not familiar with the intricacies of your international courts and tribunals, but in South Africa, as an example, what usually happens if there's a constraint by the legislation in place, processes where judicial officers could set practice directives. So they don't circumvent the legislation, it merely augments the practical application of whatever it is that seems to be the constraint. And I'm wondering whether there might be a framework to construct, specific practice directives against a particular need as opposed to rule jungling the whole set of procedures.
Right. Right, so kind of more frameworky type of things which you could then apply. Yeah. Yeah. Anything else on these procedures that you see? I mean, Christina, from all the national courts that you've ever looked at, and there are 300 zillion of them, anything that resonates specifically here? Or, I mean, maybe also to see, is some of this fundamentally different than the kind of court reform things that you've seen at the national level?
Well, certainly this need to have legitimacy in the legal profession, both in terms of common law and civil law, isn't very common at the national level, right? You usually, even if there might be countries that have some division, the court itself rarely has to use procedures that speak to legitimate kind of and customs and acquired practices of both sides. That's very different, and I'm just sitting here sort of thinking about the complexity of that. That's really something, and deciding something about how to define pre-trial and trial procedures. My gosh, to do something that has to work across those two systems, that's really complex. And the other thing that I think is quite different, for all that you mentioned, that the establishing the sort of overarching rules for governing courts might be complex in other places involving ministries of justice and so on. Very often, judges inside individual courts can just issue the rules of order for their court. Now, they can't conflict with national constitutions or with, but really in terms of, we've just decided that what we think is enough time for this stage is going to be 5 days, or, whatever. In this court, this is how this will go. In this court, we're going to have all the parties come and meet with the judges before the trial begins. So it sounds like those things are really quite different, really special and more complicated in an international tribunal.
How would you say, Thomas, or Judge Bokar, how would you say that the consensus on the basic parameters is, let's take the ICC as an example, is pretty much set at the level of the Rome Statute, the Rules of Procedure and Evidence, and that there would be enough room to work with the rules of court and the regulations, whatever, to do what now needs to be done? I mean, are there any very specific political or other hot potatoes that really create an allergy and do not give room for judges to do what they do at every single national level, namely take control below the level of generic, and also legislation? What you more and more see is legislation that is more open-ended, which allows judges to interpret and to create space.
I think one of the issues at the ICC is that states in the court hold each other in a grip, and so it blocks creative decision making almost. If you think, one way to look at it, and to unblock that, you need either to sever the tie between states and the court, which is not going to happen because states don't want to give it up, or you need to make sure that you have the best professional judges possible at the court who can deal with the space that they are handed. Because I think, again, if the rules are truly permissive, then judges can make professional decisions and use these rules. That's along the lines of what we've seen at the ICTY. And it means that they can probably overcome traditional divides, insofar as they really exist between common law and civil law. I mean, I worked for a lot for the American judge, Judge Walt, at the time at the ICTY. You might remember, of course, it's an American judge, but used, for example, the liberty that she has on the bench to actively engage in the trial, much more than she would as an American judge. She said so herself. So it's an example of someone who's able to overcome those traditional perceptions, I felt.
Yeah. Judge Bokar, do you have any reflections on this?
Well, I have the impression, maybe I'm wrong, that the rules of the ICC allow for less flexibility, because they are far more detailed than the rules of the ICTY or the ICTR or the Sierra Leone. and may be difficult for judges, I don't have any evidence of that, may be difficult to overcome some of the details in the rules. If you have rules that are too detailed, it becomes difficult to go by interpretation. And maybe this is that was the result of the difficulty of merging or compatibilizing common law and civil law, and the rules reflect both, but there is too much of each. And it's difficult. I think there may be a difficulty for the ICC. So rules should be more simple in a way and allow for more margins of interpretation. It's difficult to do it now because it should have been done properly at the beginning, which.
No.
But then there is the problem of having the judge can almost always intervene and do what they want in a case. Because if you invite parties to bring their motions within X time, they will do it in writing. Then you have to wait for the response of the other party, you reply, and then you have to translate, perhaps in different languages. And at the end you waste years. If you do it in a hearing, say what do you have to say? They will have to do it immediately, and you decide immediately. That's finished. You may go much faster if you do that.
Yeah.
But it then means the judge must be fully prepared.
Yeah.
Which is extremely important. You must have a full preparation, know perfectly the dossier.
Yeah.
And then you can do that.
Yeah.
But you need to prepare for that. And frequently, maybe because of the common law initial approach, judges started the case saying we have to listen to what the parties speak, which is not true even in the States. Because I spoke to certain judges in the States, they go, of course they do. They intervene. They intervene. It's not true that they just listen.
Maria.
I'd like to ask the judge, the prosecutors all meet almost annually. They have a prosecutors colloquium where they share experiences and lessons learned and all that. I was just wondering, at the level of the judges, sir, do you have such interaction with your colleagues from the other court? You come together.
It happened in the beginning, 2 or 3 times. We had some meetings with the judges of the ICC, but then the ICC judges dropped it. They didn't want to have it. So we went to the ICC, some of us at least. But then when they had to come to us, they didn't come. So they had, because we wanted to exchange. It was dropped. It was not,
It's also a very sensitive issue. I remember some discussions amongst judges where the very idea of judges sitting together and agreeing on something made some judges very uncomfortable as part of their work ethics, because you have your independent mind. I mean, so there's also a bit of a cultural, perhaps, explanation for this. Now,
I wonder whether you need to agree. Maybe it's just to
discuss. That's a very good point. Okay, we've got. I think this is very useful. This is very useful. Now, I only have my watch. We have maybe about another 10 minutes. Maybe we just devote some time to the issue of cost, because that's the other. There are many things these courts should do. Maybe many things they don't do quite perfectly yet, but procedures are too long and they cost too much are the issues that you hear most. We've just had a few ideas for or thoughts on where these courts might cost them us, and I think there's one important hidden cost shell in these courts, namely the complementarity thing. So you've got I suspect you'll probably end up, having 100,000 euro, 100 million euros a year, grosso modo, what the ICC will cost for now and forever. It could be a little more, a little less, but that's probably the ballpark figure. and then you've got the costs for the national system. I mean, is it a lot?
In comparison to other things, I mean, if you look at it relatively speaking, it's
2
not
weeks
that.
war in Iraq, right?
Well,
Was
yeah,
Sheffer right?
well, the lighter was at 6 billion in 2011 for the cost of combined of the international tribunals, whereas what is it, the U.S. elections for 2011 were 16, was it? I don't have the exact figures, but
Right.
in comparison to other things, I don't know how helpful that would be. It's international criminal justice via these tribunals are not that.
But why is it so hard to make the business case then? Why does this keep popping up?
It's still a lot more than national procedures, which, I mean, obviously there are some good reasons for that. But I think that's part of the difficulties with making the business case, because it comes up over and over again. Why does it cost you X
Did
amount
you
to
see what I
try
found
and
on the U.S. federal thing? I'm sorry, I didn't know right here. Okay, in the blog. I looked up what the national audit, what the president of the Supreme Court of the United States reported to Congress on the expenditures in 2012 for the Supreme Court plus all the federal courts
It's,
plus 2 other offices. How much is that? That's staggering.
it equates to 0.2% of the U.S. total budget, and that's 6.97 billion per year. Whereas, the Morton Bergsmo estimated that 4,000 people working for internationalized jurisdiction like the ICC would cost about, or the total of the roughly 4,000 people at the international and internationalized tribunals is 500 million per year.
Yeah, that's all the courts.
All of ICTY, ICTR, SCSL, ECCC, and ICC.
I think it's difficult to compare the cost of domestic justice with international justice, because domestic justice, of course, will be far more expensive, but which is the number of cases.
Right.
That they pay domestic. In all fields of law, it's here it's very limited sector, so it's rather difficult to say that to compare. It's very difficult. It's easier to compare with a day of peacekeeping in a place, for instance, with humane expenditures. I mean, that would be easier.
But it would seem that the issue of cost is very much connected with the issue of procedure, because if the simple reasoning, you've been in existence for 10 years and you're going down 2 cases, therefore you cost too much. Is that what do you pick up from the States, Thomas? I mean, what's the kind of...
Well, it's a very diverse attitude. I think there's a perception among states that these courts are not well managed, and it's a pretty strong impression, pretty widespread. And it goes particularly to the ICC, and I think states more and more looking at the ICTY, in fact, in spite of what you said about the UN bureaucracy, on how you manage such a place. And states are focusing on that. They look at budget, they look at what happens in registry, look at what happens in prosecution, and see it's quite unsuccessful in terms of, this is a perception, in terms of success rate. And so the perception is, if this is all that you can give us in terms of outcome, and if what we hear also coming from within the court, outside in terms of management, in terms of happiness, in terms of professional development, all these things, then it's too expensive. But that's another way to measure.
No, but that's an important observation. That means that the expensiveness is measured in relation to a number of things, which if you improve them, then they may not be seen. It may not be seen as too expensive.
But you have the new register, Herman van Hebel, for example, in his first meeting at the Hague working group, said that he believes that there's not enough money for prosecution, and that more should go to, if you look at the number of investigators at OTP, there are fewer investigators there than at the STL. I'm not sure it's true, but that's what he said. And so that's he's making the business case for the prosecutor to actually get more money there, and I think he was even suggesting that money could be taken from registry and reallocated to OTP. And that, of course, has enormous resonance with the states, because that's serious. It sounds serious.
He said that to the audience. He's giving some posts.
And you'll hear a lot of defense counsel argue that defense funding is way too low, that it needs to be increased to keep up the quality of arms with prosecution. I know I did a short internship with defense at ICTY, and that was always the biggest complaint coming out of defense is there's just not enough money for resources.
that's something that I'm not sure what the answer is, but I hear that too. Yet there are also a few people saying that if you look what a senior trial attorney for defense earns, it's more than what a senior trial attorney for OTP makes. But the disparity in means that he has to his avail may be in, for example, the time that he has available to prepare his case or to actually go through disclosed documents, or maybe the number of staff that he's allowed to recruit. I don't know, but just to say, look, he's earning too much or there's not enough money, there's more to it. We need to look more closer into what's really going on, how that money is allocated.
And it's at least from my understanding at ICTY, it's they're not really, they just kind of give a lump sum to the defense to run the case, more so than give this to fund the defense for all of its expenses. They just give them a lump sum, and then it's up to the trial attorney to allocate how that's spent. And a lot of that seems to go to salaries.
I'm not going to say that there isn't inefficiency and mismanagement, but I think one of the things with costs is that there's, as we were sort of alluding to in the discussion, that there's a perception that the deliverable in terms of trials is convictions. That's what you're aiming at, and if you don't get a certain number of convictions, then the court has failed, which is obviously problematic on a number of levels. I mean, that it underemphasizes the process, it underemphasizes complementarity, and of course it underemphasizes the rights of the accused in the position of the
So better management of outcomes, better definition of outcomes, and then measuring of what outcomes are. That's kind of what you were saying as well. How do you measure? Is that what you're saying, Shel?
Yeah, I think so. I mean, I don't want to give that as a blanket excuse for what's happening at the courts, because I think there are some major inefficiencies, particularly at the ICC. But I think you can't define success just in terms of convictions, obviously.
Yeah. I think everybody would agree that. I mean, does the
Well, I think this goes along with the issue of management, but you were hinting at that earlier with the issue of doubling of efforts, finding efficiencies. At least speaking specifically structure, with regards to the structure, there's several offices dealing, for example, with victims. So review of what it is that they're doing, what their mandates are, and finding efficiencies there.
Right.
Could be something it means unifying a certain office to become one, or
I think the courts as well, they need better support from states. And I'm not just saying in terms of just anteing up funding, but even just support in terms of cooperation.
That's the cooperation thing that you were talking
Yeah, I
about.
think at the beginning, for example, the ICC was in some cases doing joint investigations where they'd be working with national investigators, but they're not doing that anymore. I mean, to the best of my knowledge. So, I mean, I think if they had more support in their work from states, obviously that would help to deal with the
support,
resource issues.
like support, financial support.
Yeah, financially, but also less directly financially, just kind of added capacity, I guess you could say, in a sense of aiding the court, working with the court in terms of the whole gamut of the court's work. Whether it's, for example, aiding investigations or giving access to witnesses and facilitating that.
That's the whole cooperation routine.
Yeah.
Yeah. No, but I can, as a general idea, but I remember from the what is it, over 150 forensic investigators from, God, I think it was around, 20 teams that we sent into Kosovo. It was very hard to do because the ICTY prosecution was very worried that they would collect things in a different way and they would not be seen as independent, and that the defense counsel would raise issues, and they had different protocols, and it seems so basic, but it's an easy thing to do. But that's obvious. What about just last on the complementarity thing? I mean, to what extent do we know or see that states are actually taking this? In many ways, the costs of the Hague could be less if there's more nationally. But nationally, we're not. I mean, Christina comes from a world that I only got to know in the course of my working for Hills, like the billions and billions and billions and billions of dollars that have been spent on improving rule of law at the national level. Only small progress has been made. So how can we be more clever about that? I mean, there's not a lot of track record to go by that if you sink in lots of money, that then the rule of law in a lot of these countries will be better so that they can do their stuff.
I think the court of Bosnia is sort of held up as a good example of that.
Okay. And how did that work?
Well,
What
just
made
in
that
a very
specific?
basic way, it's become decreasingly internationalized. It started
So
off
it started
as quite a
internationalized?
hybrid court. I mean, this is the War Crimes Chamber at the national level. And that was always the intention, that over time it's become less international. And you could say that the national authorities have benefited from the expertise, but at the same time building up their own expertise, and even in a basic material sense, like building a prison.
So that's an example of something that really works.
Yeah, that this kind of approach should be used as much as possible, I would say.
This is a father that has to choose his children over international justice. I'm very sorry.
Bye-bye.
Please, children take precedence, always. Okay. Yeah, please go ahead, Maria.
Perhaps there should also be more communication between the funders and the actual practitioners. For example, in Sierra Leone, they have what they call it's headed by the Ministry of Justice, and they have a group of donors and the actual practitioners, either on the private and the government level, who then make sure that the millions of dollars that are put in are actually quite spread out properly. So
Right.
so that there's a few overlaps, so that 20 donors don't do gender-based crimes, for example.
I've often wondered that. I mean, is the Special Court for Sierra Leone an interesting, innovative funding model? Because when it was created, and it was voluntary contributions and all that, I argued in an article, and many others, that it was bad, because you need to have your funding spread out as a court, otherwise you're too... But when you look at it now, it's been a fairly efficient court.
It's very efficient.
It's...
As I said, I've been to other courts.
It had this management committee of states that contributed. They were very much involved with their court. They made sure that they managed it very closely, sometimes annoyingly closely for the registrar and the prosecutor. But is that a...
I don't think they've ever been annoyingly close.
Well, I remember some conversations were convincing me, oh God, these guys are driving me mad.
Yeah,
But
in
I
the
mean,
beginning. Yes,
yeah,
it would
yeah, yeah.
But I think it's been a successful model.
It is an interesting
everything's
one.
relative, of course.
Yeah. Okay, well, you might put that up as an interesting alternative funding model than the voluntary contributions model that you have.
It needs a review. I think it needs some
Right.
some amendment of some sort.
Did you ever, Judge Bokar, especially in your time as president, when you were negotiating and dealing with the budget of the ICTY, feel that that the states would really be serious about withdrawing on some issues, or was it due through the normal UN system, assessed contributions? It was.
I think it was. I never had a real problem with this budget, actually, in negotiating the budget.
No.
In those times.
Right.
Now it's different.
Right.
But if we asked for more resources, I had more resources.
Yeah.
You see, with the UN Security Council, it's a question of credibility. It depends how you present the issues.
Yeah.
The first day I became president, I wanted 3 more judges. And they were discouraged. They don't even try to have them because they will never get them. Reserve judges for the big case. Went to New York. In 1 month, I had 3 judges. But you must be credible and present a good case. Sometimes it works. Even with the SABQ, it works. Because at the end, that's the body
Yeah.
that you have to persuade.
The holy body.
And it's not very easy. But they put the money, there's no problem. If you show that you have a good case. It's that sometimes I guess it's the same with the ASP. It's a problem of presenting a good case, having a good case in your hands, which is not always
is more micromanaging than the ACIPQ
Right.
or the Security Council
Right.
or the management.
Yeah.
Committee.
I think you're right.
That really gets in the way. 40% of my time is spent answering questions
Yeah,
from state parties,
that's true.
everything.
Yeah.
Whereas with the management committee, if you have a good management, they feel like partners. They feel like you feel as if you have partners to talk to the others, member states.
Yeah.
Because they're with you.
Yeah. No, that I would, the Committee on Budget and Finance and the ASP.
So what is it then, at least first, the next question is why would they be micromanaging, right? Is it because the court is not presenting a unified argument or, you know, I mean, as Judge was saying, it's like presenting one court, right, what would be?
I felt it when I was before this committee, but that's of course now, what is it, 6 years ago, 5 years in the beginning, it was because everybody felt so much ownership.
Yes.
So, you know, the CICC felt it was their court, so they were micromanaging. The states felt it was their court, so they were micromanaging. And my perception often was, gee, I'm trying to set this up, please trust me, let me go with it. Leave me alone on some of this. And then, so I think that definitely was an element, but that you earn the trust
And
through success, as you say, credible case, and then slowly, like in a good company, your supervisory board leaves you more alone as management because they trust you're doing a good job. Yeah, but I think that was definitely an element. Michelle.
You know, we struggle with defining boundaries between governance and leadership and management in national courts. And it's common knowledge that in courts where there's more convergence and there is a platform of leadership that speaks to, we own this with our lives and we suspend little territorial micro petty issues and look at the ambition for the court improvement as a whole, things ultimately work better, despite not having enough fiscal resources. But I think the material goodwill in a leadership governance framework, I think, whether it's in a national environment or whether it's an international court, the variance is in the complexity of the structure, perhaps, but these are fundamentals in organization. And so sometimes I think we miss it because, you know, we speak to the politics more than we speak to the operational framework. With all of that, my question was, you know, is there a clarified set of boundary lines between the governance and leadership and operational accountabilities for some of these courts?
I think it's in the process of being worked out in many ways, at least. That's how I feel. I don't think that's completely settled
I
yet.
think it's in the ICC, the feelings is going to be generational. It's a generational issue. I think what you said about the ownership issue is very real, and it's not negative. It's positive. You know, the states are so much more invested in the ICC than they were everywhere with the ICTY, ICTR, and they feel pride in that. And the Hague Working Group, the New York Working Group, are always there. They're always engaged, and I think it will be a generation in the OTP anyway. That's how we feel. That we have to work through this. We have to work through it, and we're happy that the terms are 9 years. And we don't have to have another set of policies after 3 years or 4 years. So it's a generational thing.
Okay, I'm looking at my watch. It is 6 o'clock now, but maybe just to quickly go back to this. I guess one of the things that I take away is, without wanting to be too pessimistic, but we started out by coming up with a number of things that we think these courts should do, and we've kind of been saying they're not really doing them yet. Yeah, we're still, so you know, it still very much needs to be done, a lot of this. And that's just, maybe that's something ponder on as well. So I don't know whether you agree. I don't see a lot of extremely happy faces when I look at it. I'd say that a lot has been achieved, so let's not be too pessimistic. But
Do anybody have any final additions to maybe something you thought of in the last? Maybe we can go back to the others.
Maria,
Go ahead.
I'd like to focus on the gems. I think one of the things that we should focus on is the success of the special court with outreach, for example.
Yep.
And the experience of the outreach of special court should probably be something we should look at. Because after all, at least in the OTP, we feel that our primary constituency are the victims.
Yep.
And this reaches out to the victims. So we are focused on
Yep.
victims and outreach.
good point.
It's interesting how important outreach and perception is, both for the courts, for their impact in local community, and also, as several have mentioned, with the international partners. Perception around what they should be doing, are they doing this efficiently, that sort of thing. So the courts to be carefully articulating what it is they're attempting to do, and make sure that various audiences are hearing their messages on how well they are doing what they're attempting to do.
If it's perceived as being very successful, then all of a sudden that 500 million per year doesn't seem like too large of a number.
Yeah.
And we've just really kind of solved our budget problems.
And you find champions among them. If it's the victim communities themselves who say, hey, they are making a bit of difference in our perception, then it helps.
Okay. All right. Thank you all very much for coming. I feel like we got a lot of good information today. I'm going to write a report about what we came up with today with our terms of reference, and I'll email it out to everyone later this week.